and welcome to today's webinar on how to get your deposit back. Just a couple of housekeeping rules before we start. For those of you who haven't been to any of our webinars in the past, hopefully you can hear me clearly. If there's any problems with the sound, please use the chat box on the right-hand side and we will see what we can do. Hopefully you can see my screen as well, but we won't be able to hear you. So if you've got any comments or questions you would like to ask us, please use the chat box on the right-hand side of your screen, and we will try and answer as many as we can at the end of this webinar. There's also a couple of handouts in the handout section that you can download, whether now or during the course of this evening's webinar. Without further ado, we'll crack on. For those of you who don't know me, I've been a landlord for the last 18 years or so, and I've got properties near the Upad office in northwest London and also in Swansea. And it was off the back of being a landlord that I wanted to start Upad. And the rationale behind that was, if I was using a traditional agent, I had my own tenancy agreement and I wanted to actively do my own viewings, but I still had to pay the whole price to an agent to find me my tenants. And if I chose to self-serve and use sites like Gumtree, I just found the quality of the inquiries I was getting was quite poor. What we've seen in Upad is that it takes on average 4 Gumtree inquiries to every Rightmove lead to let a property. So I felt there was a gap in the market, and that is why we started Upad. Last year we let just over 22,000 properties, but what was most interesting is the amount of inquiries we got from tenants, which gives us huge insights into tenant behaviour and what makes a property let and what doesn't. And it's with great pleasure to say that I'm joined by Ben Beadle today from TDS. Ben, can you hear us okay?
Yes, loud and clear, James.
Thank you so much, Ben, for joining us. Ben runs one of the deposit schemes, TDS, and has an absolute wealth of information. I'm yet to find a question I've asked him over the past few years that he hasn't known the answer to. Really, thank you so much indeed, Ben, for joining us today. It's an absolute pleasure, and I really appreciate your time.
No probs.
So, cracking on, in the next 30 minutes, what we are going to go through is the following. We're going to talk about fair wear and tear and what we mean by that. We're going to look at some of the reasons that tenants don't get their deposits back in full. And quite importantly, and we'll spend a bit of time talking about this, is the burden of proof and what we mean by that and why it's so important in today's market. And we'll try and be a bit proactive and throw some hints on how you can preempt issues when your tenants are moving out of their property. And we'll talk about the written word and why that's really valuable. When you get inventories done, for example, you can get video inventories done, but we'll talk about why maybe the written word is potentially more important. And we'll finish talking about a few procedures that it's important all of us as landlords are aware of when going through this process and returning deposits. So going back to fair wear and tear and what we mean by that, I think it's important to say that this relates to the physical condition of a property and any changes caused by normal use. And it's really important to know this because should there be your property returned in a different condition to what it was when it was originally let, if it's seen that it was fair wear and tear, that isn't something you can make a claim on. And there's 3 key bits as to what affects the level of wear and tear. The first is the age and the condition and the quality of your appliances. So if you've got a expensive carpet or a cheap carpet and it's either 2 or 8 years old, that has a bearing on what you classify as wear and tear. Whether your tenants are on a 6-month AST or whether they've been there for 3 years, again, quantifies what fair wear and tear consists of. And whether it's 2 young professionals that are out most of the time or a family with young kids and a dog also has a bearing on what fair wear and tear is. And I think it's really important that we understand that you can't claim for wear and tear in terms of new for old or for betterment. It's seen that that is a given within the property that there will be wear and tear. Ben, is there anything I've missed off on that or anything you'd like to add in?
I think it's just important to recognise that landlords need to have an understanding of these particular concepts, because these are exactly the type of tests that our adjudicators will apply if we get a dispute. So you can get yourself on the same page at a much earlier outset if you're applying some of these concepts at the end of the tenancy.
And we'll come on to this later on, but should there be a dispute between you and your tenants that you can't agree on, what happens is it passes over to TDS or another scheme for their adjudicators to decide on what the outcome should be if you and your tenants can't reach a sensible outcome. And knowing what adjudicators see as sort of the line, as it were, is really important to know so you can preempt further issues. This bit on betterment is, if, for example, you've got a washing machine, let's just say it's a Nusi machine that's 5 years old, what you can't do is to say that that no longer works and claim the cost of a brand new Bosch or Miele machine, for example, off your tenants, because one, it has to be on a like-for-like basis, and also you need to take into account the age of the appliance or sofa, whatever it may be, and only claim a proportion on it, which we'll come back to later on. The key reasons why tenants don't get their deposit returned, and I think it's just interesting to know what these are so we can ideally preempt them prior to the end of the tenancy disputes that do sometimes occur, and this is sort of in order, is unpaid rent and bills at the end of the tenancy. So, for example, people not paying their last month's rent. I put on here not utility bills because generally gas, electricity, etc. are in the names of the tenant, and the relationship is therefore between your energy provider and your tenants rather than with yourself. Items in the property that are stolen or missing. Damage, whether this is indirect or direct, and also lack of maintenance. So maybe if I just pick out an example and Ben, tell me what your thoughts are, but if there's a washing machine and the tenants have been in there for 3 years, but they haven't in those 3 years ever sort of cleaned out the filters at the bottom of the machine, for example, or checked that there isn't just stuff that builds up in the rubber drum, is that seen as negligence, or is that seen as just fair wear and tear from your perspective?
Well, I think we would expect generally for the tenants to do all of those annoying little jobs that a homeowner would have to do. So that includes cleaning out the filter on the washer dryer. It includes cleaning and changing light bulbs. So we would expect those types of things to take place. And I think if those day-to-day bits and pieces haven't been done and there was a knock-on effect on the lifespan of the machine or so forth, then we would say that the landlord would be entitled to make a claim. But obviously we can only do that if we're satisfied that there has been negligence building up over a period of time. So evidencing that through property visits and emails and so forth will be really important in determining that claim.
Thank you. Cheers, Ben. And I just think it's useful to throw a few examples into the mix here so that we can all understand where the line in the sand actually is in these particular scenarios. But the biggest reason why there are disputes relates to cleanliness. It's something like 60% of all disputes, I think, on average. Ben, is that about the same percentage that you see at TDS?
Yeah, absolutely. It's there at just under 60%, but it's there normally in some way, shape or form, whether it's general cleaning, carpet cleaning, window cleaning or whatever. It's a big issue because one person's clean is another person's dirty.
Thank you. No, I quite agree. And this, interestingly, leads on quite nicely to the burden of proof. And what I mean by this is that we as landlords don't have an automatic right to keep some or all of the deposit, and it's not our money. And I think it's sometimes important just to mention that if there is a case that we think the property has been returned in a different condition to when it was first let, and this is outside of what you'd expect from normal wear and tear based on who the tenants are and how long they've been there for, and therefore we need to be able to prove that the property has been returned in a different condition to what it was when it was first let. And it's being able to prove that on the balance of probability. So should there be a dispute, and it goes to Ben's arbitration team, in order to make a claim, his arbitrators need to be able to say on the balance of probability, the property has been returned in a different condition, whether that's to do with cleanliness, for example, or any maintenance that hasn't been carried out, like the washing machine we talked about earlier. One thing I do want to point out, though, is I think that in the majority of cases, something like 98% of all cases, there's no dispute with tenants, and money is returned quite amicably. But it's always those last 2% that drags on, takes up time and hassle factor in being able to prove a situation that I think we want to try and preempt. So I've put on here sort of 6 key things that we can do to try and preempt issues arising at the end of a tenancy agreement. And the first starts with doing monthly or bi-monthly checks on your property, which actually may be a requirement by your insurance provider that you go around and visit the property. And I think this leads into the fact that you can then remind tenants about keeping the place clean and what their obligations are. You can mention things like the washing machine we talked about earlier and clearing hair out of the shower drain as an example. But therefore you can remind them during the course of the tenancy what their obligations are. And whilst it may stipulate what these things are within the tenancy agreement, I think it's a known that most tenants don't necessarily read all of it. And I think it works in our favour by being proactive and reminding tenants what their obligations are, and that they have to return it in the same state that it was first let. And I think if you remind them several times during the course of a year, rather than everybody finding out what the situation is right at the end, you're avoiding conflicts that can occur. The other bit, and we're sort of still in that climate in terms of sort of the winter time when there's a lot of damp and black mold that appears. And this is quite an interesting one because generally, especially sort of winter time and autumn, when windows are increasingly not being opened, we've got the rise of open plan kitchens. So the idea of from cooking, steam not being able to escape because all the windows are closed, also from the bathroom, etc., and people drying their clothes inside. If you remind tenants when you go around there that if you see condensation on the windows or black mold, it is not the fact that there's a damp problem of the property. You'll be able to tell if it's black mold or condensation that this is because there's just not enough air being circulated, and there's a question of literally opening the windows and just being aware of that issue. But I think nipping these in the bud when you go around there is really helpful, and it allows you to deal with any maintenance issues before they become a bigger thing. I think it's far easier to nip stuff in the bud rather than at the end of the tenancy agreement. And I think the final point I put on here is about cleaning. And one way of just overcoming what Ben's point was earlier about what one person thinks is clean is going to be different to somebody else's, is if you put in a clause into your tenancy agreement that the property needs to be professionally cleaned at the end, I think that's a very good thing to do. But it's also important to make sure it's included at the start of the tenancy agreement as well. Otherwise, it's a bit of an unfair term. I'm also of the view at the end of a tenancy, if there is an issue, it's better to try and negotiate with your tenants and reach that amicable solution, because it just avoids conflict, it takes up less of our time, and I think it's a more amicable way of trying to sort things out. But what you do know is that you've got Ben's arbitration service that's available should there be a dispute. Ben, is there anything you want to add to that before we move on to the next bit?
Yeah, I'm just thinking in terms of timescales, you're absolutely right. Negotiation is really, really important, and as you rightly observed, 98% of disputes are resolved through meaningful discussion. Sometimes people don't always agree, but they begrudgingly agree, and that level of agreement is better than disagreement. So having a really good go at making sure, A, that your charges are fair and reasonable and take into account things like betterment, all the things that we've discussed, before you put them across to your tenant, and then making sure that if you are in dispute or you're having difficult conversations with tenants, that you form a view about whether or not it's worthwhile going to adjudication. You will get a decision back within 28 days of receipt of the evidence, but you've got to factor in your time in filling the paperwork, uploading the evidence and all that sort of stuff. And I think that becomes less worthwhile if the amount you're disputing or that's being disputed is a low sum. So I think, you know, as the disputed amount increases, the more worthwhile it is to pursue to adjudication. But that's a balance that landlords need to raise in their weigh up in their own minds.
Thanks, Ben. And I think just before we move on to the written word, I just want to finish off on this negotiation bit, and that it's really worthwhile in my mind to listen to what your tenants are saying, provide reasoning if you think items have been returned in a different condition to what they were when they first let. Show them the calculations. So, for example, if it's to do with cleanliness or an appliance that's not working, show them the receipts so that you've got something to back it up. And I think finally, just be aware of compromise. It's really important to try and reach compromise. Say you've got a claim for £300, you know, to argue, if your tenants think it should be 200, to argue over £100 in terms of the hassle factor involved, the work you've got to do to go through to arbitration, it just might be worthwhile reaching an amicable solution, and just be aware of that so that everybody can sort of move on. But the key bit that will support any claim is about the written word, and it's all about evidence, because without evidence, to be able to say how a property was at the start, you don't have anything to say how it was. It's just one word against another. And talking earlier, we mentioned that when it goes to arbitration, there's this burden of proof, and to be able to show that the property has been returned in a different condition, that burden of proof is about showing what the condition of the property was when it was first let. So in a inventory, which is done at the start of a tenancy agreement, it will clearly outline the condition of the property, the hygiene, quality of all the units, etc., etc. And thereby, you've got a flag in the sand about what the property was like right from the very beginning. It therefore easily spells out the condition of the overall property, whether there's marks or cracks on the wall, so that any discrepancies are easily to identify. I think it's good practice to attend the reports. It's not essential, but I just think it's best practice to make sure that everything is covered off. Make sure that whoever's doing the inventory for you gets high quality photographs done of any questionable areas. So, you know, if there are cracks in the bath or something, make sure that anything like that has got photographs taken, and also of all of the appliances in the sense of meters, readings for gas, electricity, etc. And also, there's a bit of a view about videos and whether they're worthwhile or not. And I think there's an argument that some people believe that having a video recording rather than the written word is more valuable, because you can see so much more in an image compared to the written word. But Ben, from the side of an adjudicator, is that right, or do you see things differently?
Well, I think videos, shouldn't be ruled out, but I do believe that an inventory supplemented by photographs is probably the way to go, because it just allows you as a landlord to describe a bit more accurately about what you're seeing. Because when you're looking at videos, A, they will potentially be quite long, and B, they may not always quite clearly show what it is that you're wanting to convey. So if you're wanting to convey dust on a skirting board, for example, that can be very easily described. It may not, depending on the quality of the video, show up, and that's some of the difficulties we have with this type of evidence. So a big tip for landlords out there is, if you can get an independent inventory done, but go for the inventory and photographs embedded within that document rather than anything else.
Cool. Thank you very much, Ben. Much appreciated. When you get an inventory done, there's three parts to it, so I think it's worthwhile just mentioning what these three bits were. The first is generally called the make, which is the thorough report of your entire property, and details everything that's within it and the condition of all your appliances and furniture. And then you have a check-in, which is what is done just before or on the day the tenants move in, which includes a schedule of condition. And this is to put that flag in the sand, as it were, about the cleanliness, to take the final meter readings and any amendments. And one of the things that I'd recommend is that tenants turn up when you're getting these done, because it allows them not just to check that everything that has been recorded is correct, but it makes them aware that you're getting this report done, which shows what the state of the property was when they moved in, and it just puts them on their guard, as it were, that should there be a claim, they know that they need to return it in the same condition as what it is now. And I think it's just important that tenants are aware that you're getting this done. It's quite a useful tool to ensure that your property is more likely to return in the same condition. And then the checkout, which I think generally in a tenancy agreement, it's the tenant that pays for the checkout, and the landlord pays for the other two. Is that what you see as well, Ben?
Yeah, that's fairly routine.
So it's normal practice for the landlord to pay for the first two bits, and then for the tenant to pay for the checkout. We have actually had a question that's come in, which makes sense to sort of answer now. But Ben, let's just say there's a rental property of mine, and I had an inventory done a couple of years ago, and I've got new tenants that are moving in. Do I need to get a new make done, or can I just use the existing one and make a couple of amendments to it? Is there a best practice in terms of whether I need to do one every time I've got new tenants?
Yes, I mean, I think you could conceivably rely on the old inventory and update it, but in our experience, that does look a little like a dog's dinner after it's been through 2 or 3 tenancies. So I think if we're talking best practice here, you don't need to do a brand new make from scratch, but most inventory clerks will do an update. My one does. Will do an update to the original inventory that was done, so it's reflecting the changes from the previous tenancy, and it's presenting it afresh for the new tenancy. And I think that does 2 things. It shows to the tenant that you mean business, you're doing things professionally, and you're taking things seriously, but also, secondly, it puts you in a really good position for any potential dispute at the end of the tenancy, and that type of approach will be greatly favoured by the adjudicators if it comes to it.
Thank you, Ben. That's much appreciated indeed. So moving on, in terms of correct procedures to follow, and we'll then go on to any questions that may have come through. So please do send any questions you've got through the chat box on the right-hand side of your screen, and we will try and answer them as much as we can at the end. But the correct procedures, it's important that ensuring that your tenants have signed the inventory and you're getting a witness to it as well, just to make sure that how the property was when they physically moved in at that moment in time, everybody's in agreement about, and this is a black and white document that states how the property was. It's important to also note that at the end of the tenancy agreement, should there be a dispute, you've got 10 days to go back to your tenants and start a discussion about anything you want to deduct. So clearly, if you go beyond that 10 days, your ability to make a claim and say that there's £300 or what have you is going to be non-existent. So it's really important to know that you've got 10 days from the end of the tenancy or when your tenants move out to revert to your tenants and start that discussion. Should there be, in the unlikely case, that sort of 2%, that you can't reach an amicable solution, if there was a deposit of, say, £1,000, the bit that isn't being disputed, say 700, that amount should be returned back to your tenants, and then the other 300 generally goes to the deposit scheme to decide what happens at that moment in time. Is that the same for all 3 schemes, Ben, or does it vary depending on what schemes people use?
So for the generally for the insured scheme, that will be how it works. So if you're a landlord registered with the insured scheme, you're holding on to the deposit, you're having discussions with your tenants. Within that time frame, you will reach a view on what you want and crystallise it. You'll give the undisputed sum back, and if it's in dispute, typically the tenant will raise a dispute and the scheme will ask you for that money, and you need to pay that money to the scheme within 10 days. If the money is lodged in the custodial scheme, you will go through the same process and advise the scheme what's being disputed, what isn't. The scheme will then seek to return any undisputed sum as soon as it can, and then focus on the disputed amount for the alternative dispute resolution mechanism.
Thank you very much indeed, Ben. And for those of you using Upad, if you've asked us to register the deposit for you and hold it, is the undisputed bit will go to your tenants, and then the other part we will go to TDS because it's Ben's scheme that we use here at Upad. What you also need to do is to provide a list of all the deductions and why that you want to make on that amount in dispute. So if this is to do with cleanliness or replacing appliances, you need to have receipts to show that you have changed the washing machine or you've had a clean around, for example. And then it's a question of using the free resolution scheme that we mentioned throughout. I think you can use the county courts, which is clearly a far more expensive and lengthy course of action. But all 3 deposit schemes have this resolution service that is available to try and reach that amicable solution. And as I understand it, Ben, the adjudicator's word is final, but a landlord, if they really felt the need, could then take it to county court afterwards. Is that true, and does anybody ever go that far?
Yeah, so the adjudicator's decision is final and binding. Everybody agrees that at the outset. Each of the schemes will offer a complaints service. So that's not to overturn the decision, but if we have made a mistake or there's an error in fact or law that you think we've got wrong, then we can look at that. Once we've been through that process, and as I say, that doesn't overturn the original decision, that just puts right any errors that we've made. It is possible for you to go to the court and have the judgment set aside if that's what you feel strongly about. In our experience, we've not seen that, and if we've made any mistakes, we will put that right through the complaints process. But the adjudication is final and binding. So it's really important that landlords understand that, and tenants actually, that the court isn't necessarily there for a second bite of the cherry. You've got to be content that you are happy for whatever outcome to be final and binding, and that's why making sure your evidence is absolutely white hot is important.
Thanks, Ben. Much appreciated indeed. I just want to finish on just a couple of things that we should all be aware of, but hopefully this is just a refresher. And the first is that as a landlord, it's a legal obligation to register a deposit with one of the 3 government schemes if you have taken a deposit. There is prescribed information once you've registered that needs to be given to your tenants, and it's probably worthwhile making sure that you get them to sign a copy of it to prove that they've received it. Again, it goes back to this burden of proof part that we've mentioned previously, and just generally being a landlord, there are more and more of a need for us to have that burden of proof. So if there is a dispute, you can confirm that you've sent your tenants whatever documentation we're referring to, but getting confirmation is really, really important. We talked at the beginning about fair wear and tear, and that we can't claim for betterment, and wear and tear is dependent on how long your tenants have been there, the type of tenants they are, and the type of appliances and furniture you've got, and the age of them. There isn't just this blanket rule. I think one thing, and it's probably quite an unfair question for you, Ben, but a couple of people have asked already, but how do you decide on what is fair wear and tear? You know, if you've got a tenant that's been there for 3 years, for example, how do you classify what fair wear and tear is? Is there a general rule, or is it sort of a gut feel factor?
I mean, it is a gut feel factor, and it will be based on a whole range of things, which I'll seek to paraphrase. But there's no Colonel's secret recipe when it comes to betterment and fair wear and tear. Unfortunately, it takes into account a number of things: the age and quality of the items, the length of the tenancy, the nature of the tenure. So, if you've got 5 or 6 students in the property, the assumption is that there is going to be a greater level of wear and tear, and if you're not comfortable with that, that's something that as a landlord you need to be selective of about at the beginning of the tenancy in terms of who you put into your properties. So we will take account into all of those sort of factors that will impact fair wear and tear, and then kind of draw a line in the sand when we're looking at the evidence. So I know it can be sometimes annoying that there isn't sort of a formula or something, but a lot of these things are an opinion, are an independent
subjective, I think, aren't they?
Yeah, very subjective. And what I think may not be necessarily what you think, but the concepts should be, broadly speaking, the same, and it's the concepts upon which we can all agree.
I think it's this idea of being fair and reasonable, and trying to reach that amicable solution. Sort of arguing over £50, I think we need to really think about whether it's worth the hassle factor, and just focus on the bigger issues out there. We talked earlier about the need to communicate with your tenants. Whilst a lot of this will be mentioned in their tenancy agreement, I think there's a real need or an obligation upon us as landlords to educate our tenants and what their obligations are, in particular to do with cleanliness. We mentioned earlier that it's about 60% of all claims relate to cleanliness, so I think it's really important to make them aware throughout the course of the tenancy agreement, and really be aware that evidence is so important. If you can't prove with a written word what the state of your property was when they first moved in, the ability for an adjudicator to say that it has been returned in a different condition crudely just goes straight out the window, because they have nothing to be able to compare it to. So having evidence is so important in today's marketplace. And the final bit I'm just going to mention, because it does link in with having inventory done, is there's one of the regulations as landlords now is we need to be able to prove that the smoke alarms and CO detectors were working when they moved into the property. It's the tenant's responsibility if the battery goes flat, but we have an obligation to ensure that it's working. And just to test it is not sufficient. You need to be able to prove that it was. And the value of getting a inventory done is that that person doing it will check that the smoke alarm is working, and a third party doing that check, documenting it within the inventory is so important so that you're protected should there ever be a claim on that front. So I think it's just worthwhile mentioning that. And finally, there's a few handouts that you can download from the right-hand side of your screen in the handout section, which just gives you some information about disputes and how to overcome them and choosing the right tenant, which hopefully is worth having a look at over the next few days. And they are available for you. And then finally, there's that landing page you can see in the middle, that website link. By going to that page, you can sign up for other webinars that we do. We're doing one in a couple of days' time on tax, which is always very popular, and hopefully everybody's got their tax returns done by the end of January and not having to pay the £100 fine. But we're doing a tax update shortly, so you can register for that one. And then there's others that we do throughout the course of a month on finance, on regulations, and so on and so forth. So do sign up there, and you can follow us on a variety of social media channels if that's your thing, to keep up to date with what we see as news and what is coming up in the marketplace. We've got time for a few questions. I think if I answered some during the course of this presentation, I think we've got time for sort of maybe 5–10 minutes worth. But Ben, we've had a few questions that have come in, and one of them, well, a couple of them have been about landlords that are letting a property unfurnished. Is it necessary for them to get an inventory done if there's no furniture in the property? Is it a bit of a waste of time and money?
No, it's absolutely essential that you do have one done, because what will be present in an unfurnished property most likely is a fully fitted kitchen, fully fitted bathroom, paint on walls, carpets, wood floor, and it's all of those things that are massively important that you have descriptive content about, both in terms of condition and cleanliness. So don't be fooled into thinking that there's no furniture, I don't need one, there's nothing there to damage, plenty there to damage, get one done.
And actually, just thinking about what you said earlier, in particular to do with sort of cleanliness and the condition of the property, is actually just thinking about it is that, if there's furniture, that actually makes up such a small part of what's inside a property that could be damaged and so on, or not kept clean, that actually the kitchen, the bathroom, walls and carpet, and the state they are returned in is sort of, regardless of whether it's an unfurnished, part furnished or fully furnished property, all of those things still apply, I guess.
Yeah, absolutely, and typically they're the big ticket items, aren't they? Carpets, kitchens, bathrooms. That's where you're going to spend your money. A knackered old chair from IKEA isn't going to cost you very much, and you probably won't charge very much if it were damaged. But you would want to charge for those other things, and that's why it's important that even if the property is unfurnished or part furnished, an inventory is absolutely essential.
Thank you very much indeed. There's been a couple of questions on time frame. So I think we talked earlier about, at the end of the tenancy, a landlord has 10 days to try and go to the tenant and explain what deductions they want to make, if any. If they can't reach an amicable solution, are there any timeframes that landlords need to be aware of if it does go to arbitration? So let's just assume tenants moved out 10 days ago. We tried to reach an amicable solution, sending over the paperwork to support the fact the place needed a bit of a clean-up and some new carpet, but we can't reach a resolve. Are there any time frames of what happens next when it goes to arbitration, and what would I need to be able to show documentation-wise to your free arbitration service, Ben?
Yeah, just 2 or 3 things on this. So the first one, the 10-day timescale that we spoke about, that's actually in the legislation, and where it comes from is that the tenant makes a request for their deposit to be returned from the landlord, and the landlord effectively has 10 days to return it. So during that time frame, that's where you have your discussion. So that's where the sort of 10-day negotiating period comes from. After that period, the onus is then on the tenant to raise a dispute if the deposit isn't back. Now, typically what happens is you're having discussions, you'll 98% of the time will resolve it, the money will go back. But after that 10 days, if a tenant isn't happy with the response that the landlord's given, in the insured back scheme, they have up to 3 months within which to raise a dispute with the scheme. So it's very important that landlords and tenants don't forget that deadline, because outside of that deadline, they run the risk of only being able to go to court to have their decision or have their dispute resolved. The other timescales are once you're into the dispute resolution mechanism, is that typically landlords, so if a tenant raises a dispute, we will ask the landlord for their evidence and whether there is a dispute, and they've got 10 working days to respond to that correspondence. We then send that correspondence to the tenant, who has 10 working days to reply to it. It then goes off to adjudication. We've got 28 days to deal with it. We then pay out within 5 working days of the decision being issued. So really the ones that landlords need to worry about are the 3 months to raise a dispute in the insured back scheme and responding appropriately to any evidence request from the scheme within 10 business days.
Thank you. And I'm assuming these dates and timeframes are quite black and white. So if anybody goes over it by a day, it's sort of game over crudely if you haven't provided your evidence or made a claim in those timeframes.
Yeah, I mean, we will exercise some discretion, as I'm sure you can appreciate. You know, we want to be customer friendly on this, but you know, we do expect landlords to stick to the time frame unless there's a particular good reason that we know in advance that you might need some extra time, and we will normally facilitate that.
Thanks, Ben. And just one question that's come in is if somebody doesn't have an inventory done, they just forgot to do it or didn't see the point of it at the start of the tenancy agreement, so they don't have this flag in the sand about what the state of the property was when they moved in, what's the chance of somebody being able to make a claim? I mean, if you're able to show receipts for cleanliness in terms of a cleaner coming around and new carpet, if it does go to arbitration, I mean, is it just a case, well, they can't compare against anything and therefore it gets thrown out and money's returned to the tenant, or is there another option there?
Well, we will consider other evidence, so it's not necessarily fatal to a landlord's claim if they're missing one of those key documents. However, it's likely to be much less probable that you're going to win your claim. So we will look for other evidence, and we will sometimes see tenants that maybe say in evidence, oh, I did, yes, I accept I dropped the iron on the carpet, but I don't agree with £300 being deducted. So in that instance, if the landlord didn't have an inventory or even a checkout report or either, we've obviously got an admission there where the tenant is accepting that some damage has been caused. So in that instance, we would most likely make a nominal award based on the tenant's admission, but we certainly wouldn't be making an award of £300 or whatever it was that the landlord was asking. So in summary, we will look to other evidence, but bearing in mind that the inventory and the checkout and the tenancy agreement are your magic 3, it's likely to be a less high award than it would have been.
Thanks, Ben. Really appreciate that. I mean, I think we've got time for one last question. If the tenants didn't sign the check-in at the start of the tenancy agreement, is that fatal, or is it just sort of best practice? Does it invalidate if somebody hasn't signed it?
No. Well, we take a more pragmatic approach. If the check-in inventory comes in unsigned, but there's no complaint from the tenant that it wasn't accurate, the tenant is just complaining about what's being deducted and the value, then we will take that at face value, that document. So in that instance, it wouldn't be fatal. If the tenant was making comments about the accuracy of the inventory, never saw it, never agreed to it, never signed it, then that might be a different ball game. But believe it or not, we don't get too many challenges on this. Most parties to the dispute are accepting that the documents were done, whether they were signed or not. They're just arguing the toss over the interpretation of those documents. So in summary, it's for TDS, it's not necessarily fatal, but get it signed, because then you don't have that wriggle room or that chance of it going belly up.
It's probably the value of the third party doing it rather than yourself. Therefore, people are more likely to sort of accept that that is a true and accurate reflection as opposed to you doing it yourself as a landlord, I think. Ben, thank you so
Absolutely.
much for your insights. You have an absolute wealth of, of knowledge. You should document everything that you've got in your brain somewhere and create a book or something. But it's a pleasure to have you on, and I hope everyone found your insights worthwhile. So thank you very much indeed for your time and joining us today, Ben. It's much appreciated indeed.
Thank you.
I'd like to thank everybody for joining us today, and I hope you found this webinar really useful. You'll be sent a copy of the recording of this soon afterwards, so you can catch up on any bits that you may have missed out on. Apologies for any questions that we didn't have time to answer, but I'm trying to stick to times on this. There's also a feedback form that comes out, so any other subject matters that you think is worthwhile us covering off, or indeed how we can improve this webinar, please do feedback. It's really, really important to us. So thank you so much indeed for listening. I wish you all the very best. Take care. Goodbye.